So we have a full day, so we thought we'd start reasonably punctually. I'm Ricky Revesz. For the last 2 years, I've been the director of the American Law Institute, and I'm delighted to welcome you here to NYU Law School and in this room where I spent a lot of my life in non-ALI contexts. As I said last night, this is an enormously distinguished group, and it's a tribute to Beth Burch, our honoree, that she assembled all of you together to come talk about issues that are very important to her. The excuse for all this is that Beth won this big award that the ALI started a number of years ago, which I'll tell you about. It's an award given to academics who've been teaching for under 10 years. And the way this works is that we run this competition every 2 years, and every 2 years we select 2 people. We've run these competitions 3 times, and so there have been 6 honorees selected so far. We asked the dean of every law school to nominate one person. Actually, we didn't restrict it to one person for the first year. And some deans were very grabby and nominated more than one person. I hate to tell you that I was actually one of them, but I was wearing a different hat then. But then I wasn't the only one. But then this kind of misfeasance was ended, and now they only nominate one person. And there are lots of nominations and lots of very good nominations. There's a very fancy committee that then wades through this whole process and reads all the drafts and selects about a dozen finalists. The chair of the committee has been Justice Goodwin Liu of the Supreme Court of California. And so the first 2 honorees in the first competition were Orrin Bargill, who was then on the NYU Law School faculty and subsequently moved to Harvard, and Jeannie Fromer, who was then on the Fordham faculty and subsequently moved to NYU. In the second round, the winners were Adam Levitan of Georgetown and Amy Monahan of the University of Minnesota. And in the current round, the winners were Beth Burch of the University of Georgia and Michael Simkowitz, who's here, of Seton Hall. And Michael's conference will be next year, so I think he's here in part to to learn the ropes. And there's a lot to learn because Beth, if we had another award for the person who did the best job putting their conference together, Beth would definitely win that award. We don't, but I'm telling you, it was an amazing job. And Stephanie Middleton, who is my ALI colleague on all of these substantive matters, and I worked really hard on this, but we actually didn't work that hard on putting this conference together because by the time we turned around, Beth had actually secured everyone's commitment to participate and be on panels and do all of these things. So that was very impressive. As I mentioned, Beth is on the faculty at the University of Georgia Law School. She began her academic career in 2006 and joined the Georgia faculty in 2011. Now here's an interesting fact. Very shortly after she got this award, in 2015, she was promoted to full professor, and then shortly thereafter, she got the Charles Curbo Chair. So I think a number of you are experts in causation here, and so you can draw whatever conclusions you want to from this pattern of events. Beth, as you know, is an expert in procedure, class action, and mass torts, and I think you are all familiar with her work, and she's familiar with all of your work, which is why you got invited. It wasn't that Stephanie and I did anything very special to do this. I mean, Beth thought you would be the very best group, and we agreed. So a couple of logistical things, which is, I think, we're the only place that I can add value in this august group, since this is not my area. We will Beth will give us a welcome, and then I think it would make sense for us to go around the room and do sort of a brief introduction, maybe kind of your name and affiliation. I think most of you know each other, but it would be probably a nice thing to do. When you talk, for your introductions or otherwise, turn your microphones on. The acoustics in this room are not that great, and to do that, you press speak. And when you finish speaking, you press it again, because only 3 microphones can be on in the room. For those of you who speak at the podium, we need to keep these 2 side microphones on, which means that when we're no longer using the podium, we have to turn them off, or else people are not going to be able to speak. And if we can help in any way with any logistical issues throughout the day, look for me, look for Stephanie. And then the people who really made the logistics of this work are Lindsay Gotch and her colleague Steph Zuba, who are the ALI's remarkable event planners. They do events like this practically every week of the year around the country, and they all work out beautifully. So we are all very grateful to them, because it's not easy to do this kind of work. So welcome. Beth, the podium is yours.
Well, good morning and welcome. It's such a tremendous honor to have every single one of you here with us today. I think it's truly a testament to the importance of the issues that are confronting us in aggregate litigation that we have not only Judge Scirica and not only an all-star list of panelists and moderators, but also an all-star group of attendees. And so as I look out over all of you, I'm reminded that long before I became an academic and had the opportunity to actually meet each one of you, that I was influenced by your writings, by your judicial opinions, and by your law review articles. And it's truly an honor to be able to count many of you as now friends and mentors and critics. And it is, in fact, this sort of diversity of critical perspectives that I used as our animating organizing principle for today. This notion that collectively we're more cognitively diverse, I think, speaks to a testament that these issues are facing a lot of people in a lot of different areas. So you'll undoubtedly notice a number of familiar faces among you, people who have been laboring in this field for decades, but you may also notice some less familiar ones. Academics whose work intersects with and speaks to the problems in aggregate litigation, but who are experts in the fields of social psychology, torts, administrative law, and legal institutions. So collectively today, we include not only academics, but state court judges, federal court judges, federal researchers and executives, claims administrators, and plaintiffs and defense attorneys. So when we bring together people with such a diverse array of perspectives and backgrounds and values and analytical tools to address all of the issues that are confronting us in aggregate litigation, we stand a chance of not only increasing the number of possible solutions, but also creating different connections among those solutions. So this is, in fact, what I see as the great strength of the American Law Institute, that it is not an organization, as many of you can attest, that simply plays lip service to the marketplace of ideas, but is instead very much an avid consumer of them. So by asking our panelists today to limit their remarks to around 10 minutes, the hope is that today is going to be a highly interactive conference, and that collectively we can leverage our differences to confront some of these issues that are facing us today in aggregate litigation. So I want to sort of extend a very deep note of gratitude to the American Law Institute, to the Young Scholars Committee, and as Ricky mentioned, to the people behind the Institute. So Judy Cole, Catherine Grazinelli, Lindsay Gotch, Stephanie Zuba, and of course Stephanie Middleton and Ricky Revesz, who has so generously opened up the doors to NYU to us today and allowed us to use this beautiful facility. So I'll turn things over to Stephanie Middleton.
So I have the pleasure of introducing our keynote speaker. Before I do that, I just want to mention we are video recording this. We haven't done that with our Young Scholars meetings before, but this was such an amazing gathering, all these panels and our guests. So there's the camera if you want to be sure you sit up straight all day. So when we were talking to Beth about her program, she said, do you think we could get Judge Scirica to be the keynote speaker? I said, absolutely. Every time ALI asks him to do anything, he says yes. So he's our go-to person, especially as a speaker. I've known Tony Scirica. I was a Philadelphia lawyer for many years. Still am, I guess. I've known him for a long time. He has, I guess because he says yes, he's done everything. He was an assistant DA. He was elected to the Common Pleas Court in Montgomery County, Pennsylvania. And Montgomery County is right outside of Philadelphia. It is now where the Bill Cosby case is being heard, and also the criminal case against the Pennsylvania State Attorney General. She was indicted. He also was an elected state representative for 8 years. He was then appointed to the federal bench in the Eastern District of Pennsylvania as a trial court judge. He was elevated to the Third Circuit. He became the chief judge of the Third Circuit in 2003. He then became the the chairman of the executive committee of the executive conference of the executive council of the U.S. Anyway, it's basically the top of the federal courts. And he won the Devitt Award, and he was the chair of the Standing Council on Rules and also on the MDL panel. So he's done pretty much everything, and he's here to talk to us today about aggregate litigation, and we thank him for that.
Stephanie, thank you very much. Stephanie has assured me that I will have final review of anything that's recorded and can delete what I don't like. You ought to try to get the same from her. You know, a few years ago when I became Chief Judge of the Third Circuit, I was told that it was a little bit like being the caretaker at the cemetery. You're over top of everyone, but no one is listening. Luckily, no one could say the same thing about those who devote considerable time to our system of aggregate litigation, where the dialogue between scholars, lawyers, and judges have been robust for decades. And today's conference is a perfect example, and it is a great privilege to lead off on what is sure to be an enriching day for all of us. And so I'd like to offer some views, at least my views, of the state of aggregate litigation, where we've been, where we are, and where we may be going. No society is immune from mass harms, and each must discover ways to address and to deal with them. How that is done depends in part on its institutions and history, its legal culture and traditions, its constraints and expectations. And in our country, it is informed by our English and American common law tradition, and most profoundly by concepts of equity. No matter the device, joinder, class actions, MDL centralization, or bankruptcy, mass harms must be dealt with in ways that are structurally sound and procedurally and substantively fair to all parties. Efficiency plays a role in design and also in purpose, but the pole star should be equity. Of course, we are not the only country confronted with these issues. Despite agency and fairness problems created by the aggregation of claims and parties, other countries around the world, civil and common law countries with sophisticated legal systems, are exploring ways to fairly resolve mass claims. They are, of course, looking at the American experience. None has yet embraced the concept of the private attorney general that has played such a prominent role and served as such an essential vehicle in the enforcement of public and private rights. Few can doubt that the class action device and the concept of the private attorney general have become valuable components in our system of governance, and powerful instruments of social and economic policy, setting standards and deterring misconduct. This year marks the 50th anniversary of the modern version of Rule 23, which took shape when it was transformed by the Supreme Court in 1966. As you know, the court retained the limited fund class action, solidified the declaratory relief and injunctive class actions so essential in enforcing civil rights actions, and amid uncertainty as to consequences, created the damages class action. It is, of course, the creation of the B3 class that has generated the most discussion and litigation over the years. In 1976, Abram Chase predicted that it was unlikely that the class action will ever be taught to behave in accordance with the precepts of the traditional model of adjudication. 50 years later, I have to say that I think it has behaved pretty darn well. Sometimes how you frame the question tends to suggest the answer. As Sam Zakharoff once remarked, if you start with the perspective that the optimal resolution is that of the single plaintiff and single defendant, then everything else is a deviation and has to be justified. But if you begin with the perspective that mass harms are a fact of life, then the perspective is different. Perhaps you don't need to justify the deviations, or at least not in the same way. Or perhaps it is more accurate to say that you still struggle with the deviations, but you do so in a different way. The question then becomes, how should mass harms be resolved, and who or what should resolve them? In our attempts to answer this question, there have been some landmark moments navigating between the polarities of the two perspectives, individual litigation and aggregate treatment. Certainly, Amchem and Ortiz were landmarks, Ortiz extolling the single plaintiff model, Amchem less so, but not by much. Each must be reckoned with in settlement classes, and properly so. Structural protections, that is, the structural assurance of fair and adequate representation for all groups and individuals, and due process must be safeguarded. Beyond Amchem and Ortiz, the Supreme Court has given us other landmark moments in cases such as Basic v. Levinson, reaffirmed in Halliburton, General Telephone versus Falcone, Walmart versus Dukes, and most recently in Tyson Foods. And the court has laid down fundamental principles on preclusion in Taylor v. Sturgill. In the MDL area, the adoption of the multi-district litigation statute and the discerning and resourceful actions of the MDL panel and the transferee judges have permitted the fair and expeditious resolution of many mass claims. Some of these proceedings have been referred to as quasi-class actions. In the Vioxx MDL, Judge Fallon employed equitable principles and his inherent authority to bring about pragmatic resolutions that were fair and adequate to thousands of claimants. In the bankruptcy field, combustion engineering was able to recapture the equitable nature of mass resolution of similar claims. Congress, too, entered the fray. The Private Securities Reform Litigation Act responded to perceived abuses and strike suits in private securities actions by amending both the substantive law and also the procedural law, by raising the bar to bring suit and giving parties with the highest stakes the ability to control the litigation. And similarly, the Class Action Fairness Act responded to overlapping and competing class actions in state and federal court, transforming the treatment of mass claims that were national in scope but lodged in state courts. These cases and statutes each contributed to the system we have today, and arguably one of the more significant moments came with the interlocutory appeal of class certification decisions. Before the adoption of 23F, there was little guidance from appellate courts as to how to make the class certification decision, except, of course, for settlement classes. Before 2000, few class actions actually went to trial, and so the certification decision was largely unreviewed, a remarkable situation since granting or denying class certification was often the defining point in the dynamics of the class suit. Since the adoption of 23F, much has happened in defining class certification standards. Lower courts began fleshing out what the Supreme Court meant by rigorous analysis of certification. Although the formulations are not uniform, there seems to be a consensus that plaintiffs must demonstrate that their claims are sufficiently aligned to be capable of class-wide resolution. And in the end, the process of class certification is designed to identify cases in which there is sufficient commonality among claimants to ensure that binding representation makes sense. When similar claims are not satisfied in a class action, we are not always comfortable binding the entire group to the decisions of steering committee counsel and representatives. Open issues remain. The question of whether statistical evidence may be used to demonstrate liability or the scope of liability in so-called trials by formula continue to challenge courts. With guidance from Walmart and now Tyson Foods, we continue to explore this issue. Similarly, courts continue to struggle with both litigation and settlement classes consisting of class members who may not have been injured. Chief Justice Roberts' concurring opinion in Tyson Foods will surely generate discussion regarding the power of federal courts to order relief in such cases. As issue classes become more prominent, they might raise difficult preclusion problems and may impact the utility of bellwether trials. Preclusion decisions also navigate between the polarities of individual litigation and aggregate treatment. And questions surrounding the superiority requirement of 23A will proliferate as other methods for resolving mass claims develop, arguably becoming superior in some instances to the class action litigation. Nor is there consensus about what many lawyers across the country have long recognized as a vexing issue in modern civil litigation, the problem of personal injury mass torts. The problem is especially acute in personal injury suits that are truly national in scope, implicating primarily state law, involving unresolved issues of causation, and sometimes the possibility of latent injury. The proposed classes in these suits are often found to lack predominance due to the individual injuries and medical histories, and due to differences in state law. These difficulties have led many lawyers to eschew the class mechanism in personal injury mass torts. Almost 20 years ago, the Judicial Conference Mass Torts Working Group tried to address these problems. It considered concepts central to mass tort litigation: maturity and elasticity, centralization versus devolution, and the incentives and disincentives of bringing suit and in which forum. Today, we still confront many of the same problems in addressing massive complex claims. Even with the 2003 amendments, Rule 23 remains geared towards litigation, but often may be an imperfect fit for settlement classes. AmCham made clear that expediency cannot bridge difficult agency problems, nor could it negate the requirements of Rule 23, which of course serve to protect absent class members. The agency problem is even more acute in the settlement class context and certainly demands heightened scrutiny. Yet, despite the Supreme Court's suggestion in AmChem, many lower courts have not embraced its directive on manageability. And in the settlement context, predominance continues to raise difficult issues with respect to individual differences on claims and parties, and more significantly, on conflicts in state law. These issues arise as well in consumer class actions, which have sometimes proven difficult to resolve through settlement. Consumer actions, class actions based on state law can involve difficult issues of reliance, which may present a hurdle to certification. In such instances, some courts have developed presumptions of reliance. Furthermore, difficulties in approving class settlements can hinder defendants from obtaining something many desire: finality in the form of global peace. And in some instances, defendants are willing to pay a peace premium. Of course, when evaluating the adequacy and fairness of class settlements, courts must be vigilant and demanding in assessing the allocation of compensation or other remedies, especially in situations involving latent injury. And so in this regard, it is useful to look again at the ALI project on aggregate litigation. The ALI's efforts to identify the proper factors to consider in reviewing the fairness of a class settlement are admirable and provide helpful guidance. Ensuring that the relief afforded to the class is fair and reasonable, that class members are treated equitably relative to one another, and that the settlement is not the product of collusion are essential components of a thorough review. And perhaps the analysis will be altered by the advisory committee's consideration of a revision, which would, as a distinct matter, incorporate settlement classes into Rule 23, establishing different requirements for class certifications in such situations. Or the advisory committee may decide that these matters are better left to the courts, allowing them to work out sensible solutions on a case-by-case basis. If so, they will follow the same course taken by an earlier advisory committee after the Supreme Court handed down AmChem. As the law of class actions has continued to develop, it is remarkable to note how many of the same principles and standards developed in the class action setting have been imported into other areas of aggregate litigation, especially MDLs and bankruptcy. The capping of attorney's fees, the structures used to ensure fairness and adequacy, and the proper and fair allocation of settlement funds are all concepts that in one way or another have migrated from class actions to both MDL and bankruptcy proceedings. Perhaps that phenomenon is a consequence of many practitioners eschewing the class action device in favor of other forms of aggregate litigation. As noted, recent cases suggest that the MDL process has supplanted the class action as the procedural mechanism for large settlements involving personal injuries. This is significant because many of the important issues in the class action setting, the agency and fairness concerns, the potential conflicts of interest, the selection of counsel or steering committees, the determination of attorney's fees, and the allocation of remedies arise as well in the MDL setting, but with a crucial difference. There is little positive law and largely no prescribed review. Aggregate settlements in the MDL setting also raise distinct ethical concerns, as counsel on both sides try to maximize the number of plaintiff opt-ins. Some have questioned agreements that require plaintiffs' attorneys to recommend the protocol to all of their clients, to withdraw from representing clients who reject it, and to forego referral fees for those clients. Yet, the absence of such arrangements may forestall the likelihood of reaching agreement in the first place. In the last 5 years, the MDL landscape has changed dramatically. Before 2000, no more than 15% of the pending civil cases in federal court were in the MDL. But since 2010, there has been a steady increase, and in 2014, 35% of all federal civil cases were before an MDL transferee judge. If we subtract all prisoner and Social Security cases, the figure was close to 45%. And close to 90% of all transfer cases are concentrated in only 18 MDL proceedings. As we know, although the MDL centralization focuses on pretrial management, over 90% of all actions centralized in the MDL are terminated before the MDL transferee judge. Most of these MDL cases are concentrated in mass torts, and most of these in products liability suits, especially those involving pharmaceuticals and healthcare. And most are governed principally by state law and involve individual factors relating to causation and medical history. As noted, post-AmChem, these cases are not presented as putative class actions, but many or even most of them are aggregated on a non-class basis. Of course, the MDL judges often have the benefit of mature claims or of taking steps to bring this about before facilitating non-class settlements or approving class settlement agreements. The need for individual trials to assess liability and the range of damages can be addressed in the MDL context. And if there is a paucity of experience, bellwether trials can be employed, often to great effect. Maturity can be crucial in assessing the fairness of a settlement, both in the MDLs and in the settlement class action. So the MDL transferee judges have extraordinary responsibilities, and in a great majority of these cases, the discerning actions of the MDL panel and the transferee judges have permitted the fair and expeditious resolution of many mass claims. Drawing on equitable principles, these resourceful judges have relied on the direct authority granted by the statute to orchestrate pretrial matters such as discovery, Daubert and Frye hearings with their state court counterparts, and dispositive motions. They have similarly relied on their inherent or implied authority or on express authority granted by contract to determine the allocation of fees and to shape settlement negotiations. There are other views, though, and scholars like Professor Burch have ably raised concerns about the selection and compensation of lead attorneys and the authority of the MDL judges to preside over private settlements. Courts and scholars have also raised concerns about the lack of prescribed review in the MDL context that may lead to under-the-radar settlements that might not receive the attention they would otherwise warrant. So too, there is limited review in another common method of claims resolution, and that, of course, is arbitration. Concepcion has amplified the importance of arbitration agreements containing class action bans and has resulted in many cases being brought through private arbitration. Some state courts have resisted Concepcion's broad interpretation of the Federal Arbitration Act, especially as it relates to consumer actions. But their views have not always carried the day, as demonstrated by the Supreme Court's decision in DirecTV. The boundaries of the Federal Arbitration Act remain to be seen, but it appears that arbitration will continue to be a common method for resolving mass claims. Similarly, out-of-court settlements like those conducted in the wake of the Deepwater Horizon disaster present both opportunities and challenges to ensure the fair resolution of mass torts. Some defendants, seeking to avoid the challenges of aggregate litigation, have designed their own system of mass claim resolution. When successful, these private systems may offer an efficient and expeditious way for plaintiffs to achieve relief without having to meet the various requirements of Rule 23. But there is no judicial oversight, which may lead to unfair results. Greater transparency and further studies on out-of-court settlements could help ensure that the process is not being abused. Principles of fairness must guide those who regulate and review these private resolution methods. And finally, in all methods of mass claim resolution, we must be mindful of our ethical responsibilities as lawyers. In the Rule 23 context, class counsel, of course, has a fiduciary responsibility to the class as a whole, and the court similarly has a responsibility to ensure that the entire class is treated fairly. In non-class aggregate litigation, the rules of professional responsibility do similar work, ensuring that each individual client can make the crucial decisions during the course of the litigation. Much has been written about the ethical issues raised by third-party funding of class actions. This innovation poses an important question. Will third-party funding impact class counsel's fiduciary duty to the class? Judges overseeing class settlements must assure themselves that the lawyers before them have fairly and adequately represented the class as a whole. Ethical issues also confront lawyers in reaching out-of-court settlements. And so, in very large measure, those who offer their time and expertise and knowledge, all of you here today, to our system of mass claim resolution, do so with the very best of intentions and goodwill. So long as we remain mindful of the principles of fairness that guide our system of justice, those good intentions will translate into fair results for all parties. Not only will our legal system benefit, but so too will all of those who look to our country as a leader in fairly resolving mass harms. I look forward to our distinguished panelists exploring these and other issues in today's conference. Thank you very much.
Thank you so much, Judge. We're actually running a little ahead of schedule, which is unusual in these situations. We're just going to take a couple of minutes to go around the room with brief introductions, just name and your affiliation. And then after that, we'll move to our first panel.
Hello, I'm Kathy Sharkey. I teach here at NYU.
Bob Rabin, Stanford and NYU.
Bob Bone at the University of Texas.
Howie Erickson from Fordham.
Jay Tidmarsh from Notre Dame.
Tom Tyler from Yale.
Mary Kay Kane from University of California, Hastings College of the Law.
Carolyn Kuhl, Los Angeles Superior Court.
Bill Heiberger, Los Angeles Superior Court.
Alan Black, Fine Kaplan and Black, Philadelphia, and ALI council member.
Judith Resnick, Yale Law School.
Maggie Lemus, Duke.
Sam Zakharoff, NYU, and also ALI counsel.
Elizabeth Cabraser, Leif Cabraser, Hyman and Bernstein, and ALI counsel.
Eastern District of Louisiana in New Orleans, and I'm chair of the Multi-District Litigation Panel and also ALI Counsel.
Bill Rubenstein, Harvard Law School.
Eduardo Robrino, District Judge, Eastern District of Pennsylvania.
Lee Rosenthal, District Judge, Southern District of Texas, the other Southern District, and ALI Counsel.
Ricky Revesz, ALI and NYU Law School, and I should point out that Judge Kuhl is on the ALI Council as well.
Michael Simkovic, Seton Hall Law School.
Tom Thrash, U.S. District Judge, Northern District of Georgia in Atlanta.
Joel Wooten, Butler Wooten Law Firm in Atlanta.
Rick Marcus, teacher at Hastings, and been working with Judge Scirica and others on Rule 23 for a long time.
Eldon Fallon from the Eastern District of Louisiana.
Tommy Duncan, Executive Director for the MDL panel.
Laura Hines, University of Kansas School of Law.
Linda Mullenix, Texas.
Ellen Huvel, I'm a district court judge in Washington, D.C., and a panel member of the MDL.
Ken Feinberg, Washington, D.C.
Catherine Perry, district judge in Eastern District of Missouri in St. Louis, and also on the MDL panel.
John Vitone, Washington, D.C., Senior Administrative Law Judge and a member of the Foreign Service Grievance Board for the State Department.
Teddy Rave, University of Houston Law Center.
Warren Brown Jr. with Brown Greer in Richmond, Virginia.
Good morning. I'm Warren Brown Sr. from Brown Greer, Richmond, Virginia.
Emery Lee from the FJC.
Francis McGovern, Duke Law School.
Michael Kaplan, George Washington University Law School, and amicus counsel to the Brain Injury Association of America in their opposition to the NFL settlement.
Troy McKenzie, NYU School of Law, moonlighting at DOJ.
Alan Morrison, George Washington Law School.
Shira Shenlin, United States District Judge, Southern District of New York.
Ben Zapersky, Fordham Law School.
Adam Zimmerman, Loyola Law School, LA.
Archie Williams, FJC.
Dave Proctor, Northern District, Alabama, also on the panel.
Patrick Woolley, University of Texas School of Law.
I'm John Barquette with Shook Hardy and Bacon in Miami, and I'm a member of the Advisory Committee and on the Rule 23 Subcommittee of the Advisory Committee.
Morning, Bob Dow, District Judge in Chicago and the chair of the Rule 23 Subcommittee. Brian Fitzpatrick, Vanderbilt Law School.
Maria Glover, Georgetown Law. Tracy George, Vanderbilt Law.
And I'm Deepak Gupta from Gupta Wessler in Washington, D.C.
I'm Alvin Hellerstein, supposedly sitting in Professor Arthur Miller's seat.
Okay, that's a tough job. Thank you everyone, and welcome. We are ready for the first panel. I see that most of the first panel has congregated over here, which makes sense. Judge Hellerstein is the moderator. Ken, I think we need you up here somewhere.
I'll be following this sequence. When you're doing agency.
Yeah, we'll see if it fits.
Oh, I think it does. Yeah, no, I think it does.
You're going to be first.
Well, I think that this is likely a panel that needs no introduction. But when I was designing this conference, this panel sort of kicks us off by looking at dispute resolution that takes place outside of the Article III courts. So be it in arbitration or the administrative law courts or private dispute resolutions. And so I will turn things over to Judge Hellerstein.
Good morning, everyone. As one who, long time ago, used to see Professor Arthur Miller doing extraordinary moderating work
on television, I will not try to emulate his style. I'd like to introduce the panel, though I think you know them all. Ken Feinberg, who is the preeminent special master, conducting all sorts of disputes resolutions and money distributions as an adjunct or as ancillary or as competitive with the legal system, but doing much more effective work than the legal system. Deepak Gupta, who's immediately to my right, Robert Rabin, who I haven't seen for a long time, from the Stanford Law School, and Catherine Sharkey. Where is Catherine? How do you do? The New York NYU School of Law. I think you're first, Ken. So
Thank you.
for a few minutes, and we'll see how far you go before you're interrupted.
Thank you very much. 4 quick points to get us going this morning. The title of this panel is Aggregate Litigation Outside of Article III Courts. Well, in all the work I've done, outside is a very relative term. The 9/11 Victim Compensation Fund, enacted by Congress, would have never succeeded without the active involvement of Judge Hellerstein. The BP oil spill fund in New Orleans would have never succeeded without the active support of Judge Barbier. Judge Fallon with Vioxx, Judge Weinstein with Agent Orange, Judge Chuck Breyer now with Volkswagen. Any role that I play in establishing alternative mechanisms to pay people must have and always have had the active support of judges who know how to manage mass tort cases. So it's a very relative term. When Judge Scirica says programs that I administer lack judicial oversight, well, it's a relative concept, I must say. I would never get away with what I do successfully without Fallon, Weinstein, Breyer, Hellerstein, Barbier. That's point number 1. Point number 2, I wouldn't read too much into what I do. I don't think what I do is really to be studied in law school. These are better studied in a history class. You'll never see the 9/11 Victim Compensation Fund again. Never. I don't think you'll see the BP oil spill fund again unless there's a company that wants to front $20 billion within weeks after the disaster. So I think what I do is not a real viable policy alternative to the rest of the day's discussion, tell you the truth. You have to have companies...
Why are you so frequently called upon?
Frequent. You can put the number of times I've been called upon since 2000 on one hand. That's not frequent.
But they are the major disasters that have occurred in the last few years.
Bad things happen to good people every day. This is not a 9/11 fund.
You may. First of all, modesty doesn't become you.
All right, this is the wave of the future, and you all ought to hire me.
I'm not sure.
Is that good?
I'm not sure these are waves. I'm not sure there's any uniform pattern in any of this. But it's interesting that you are so frequently called upon when there are mass disasters that confront supposed malefactors in ways that are extremely uncomfortable to them, and as alternatives to a court system that takes a lot longer and has many different kinds of digressions than you do.
Let me say...
So maybe it's not a policy, maybe it's not a program, and maybe it's a unique appendage of the way you do things, because you can't take that out of the picture either.
Well,
but it's interesting to me that we have done this now so many times.
Well, I guess it's all what you mean by so many times. I mean, I'm looking for work right now. I got Volkswagen, but I don't know how long that'll last. Now, no, look, I just don't think spending a lot of time on these alternative programs makes a whole lot of sense when there are real issues involving Rule 23 and aggregation under the court system.
Well,
now let me just say one other thing. There is one real goal, it seems to me, when these companies set up these programs that they want more than anything else, and it's not cost savings and efficiency and speed. That's what everybody thinks. What they really want is certainty. certainty. They want to cabinize the problem. And I must say that although Judge Scirica is correct, my last point, although Judge Scirica is absolutely correct that these programs can't guarantee global peace because you can't guarantee an end to all of the litigation. Sam's written about this. You come so close to global peace that, in effect, the peace you don't have is purely existential, I must say. 97% of all eligible families came into the 9/11 fund voluntarily. 92% BP, 95% GM. So you may not get 100%, but the valuation and the uncertainty of what is left is so de minimis that when these programs are implemented and fashioned, they do exactly what, at least in the few cases I'm aware of, where they achieve the same objective.
So how do you make your program so attractive?
How do you make them so attractive? You pay people a lot of money and you pay it quickly.
And how do you know, what kind of criteria do you use to determine what a person is worth?
What they're worth?
No, that's a bad question because you already taught me by your book, what is a life worth, that you can't measure it.
You basically measure the way the tort system. Bob Rabin teaches every day how you measure what is a life worth. So economic loss plus pain and suffering.
So you take the people in, and in effect you're telling them, I can give you pretty much the same as you may get in a lawsuit.
As you told all of the 9/11 families, if you come into Feinberg's program voluntarily, you'll get as much or better than if you stay in the tort system with its uncertainty and prevail.
And do you give a release?
They give a full release.
So if someone takes money from you, that person can't ever sue.
They can't sue the company that paid the freight, and they can't sue any co-defendants because they're getting 100% of their damage.
Suppose they put in a claim but don't collect.
I'm sorry?
They put in a claim but then they withdraw.
Sue.
They can sue.
And now what you're seeing with GM in Judge Furman's court, people are suing and getting kicked out without a claim, summarily.
So what you're doing is, in a very sophisticated way, calculating the values that would come from lawsuits, and you're establishing some sort of process that gives the people a sense of fairness, and you're assuring them speed.
Yeah.
So those are extraordinarily great benefits.
Yeah, great benefits. You're delegating all of this authority to me. There's no checks and balances. There's no committees. There's no appeals. And I wonder about, and I'm not surprised that these programs are therefore so rare. And besides, companies don't want to put up this type of money without litigating. Their shareholders don't like it. Investors don't like it. And study it in history class.
Questions? Yes, Judge Rosenthal.
I take your point about the distinctive nature of the cases in which your fully developed approach has application. But are there aspects of the program, the Feinberg program, we can call it, that are exportable to more diverse kinds of cases, both in scale and scope and severity of harm?
Well, I think the conceptual point of using tort concepts or related concepts under a court umbrella to implement settlements under the watchful eye of the district judge, sure. I mean, I'm not sure there's much new about that, except I'm not sure how many Fallons or Weinsteins or Hellersteins there are who are willing to take on that managerial responsibility. When I go to the Federal Judicial Center to talk about this, it's like Latin to a lot of federal judges. Ask Judge Fallon and Judge Hellerstein how you go about taking advantage of some of the efficiencies and certainty of what I do and apply it under the judicial umbrella.
We can be taught. We are educable. It's not easy, I grant you that.
Well, there's not much we have to do when you take a case and the person goes into your system. People are extremely, at least from my 9/11 experience, they're extremely wary, they're distrustful, they're skeptical. They've suffered an enormous tragedy and they don't quite know how to do it. They were suspicious of what you were doing, and you set up some very interesting institutions to allay their suspicion. For example, they could come in and get advice from you, an informal opinion, as it were, of how they would fare, what they would get.
Yeah, you have to be a shrink.
And you heard people. You let them tell their story. And I don't know if that happens in all the cases. And I saw that it was to my great advantage to let you do as much as you could do, because there was not enough time or money or effectiveness for me to run all these cases. So the more that you did, the easier it was for me. So naturally, I wanted you to succeed in the best possible way.
Now, let me just make one other point. To the extent I've found that to the extent that there are trial lawyers who are very skeptical of what I've done, I think that they have great credibility in that skepticism. I don't think you hear all this talk about, well, I'm taking away fees and all of this. I don't really think that the primary skepticism of some members of the trial bar is because of financial reasons. I don't. Trial lawyers at NYU Law School are taught about the adversary system. You pick your lawyer, I'll pick my lawyer, judge and jury. That's what they're taught by Bill Rubenstein and others. Well, that's the system. And when you see something that is not the system that they've been taught and revere, and it is delegation run riot to one person, very efficient, very certain, very effective.
But you can't succeed, Ken, unless you can honestly tell people that you can give them pretty much the same money they would get if they succeeded in the tort system.
Or more.
And usually, I don't know about more, but you don't have to say more. You can just say as much. You won't have to pay the fee. You won't have to pay a third, because you limit what attorneys can get.
Or Congress does.
Or the company setting up the fund does.
No.
Well, typically when people came to you in BP, did lawyers get a third?
Ask the lawyer and the individual claimant. Neither Congress nor I had any say over that at all. Here is your damage. However, your relationship with your own private attorney, that's your business. I've got enough problems without worrying about attorney's fees.
So in 9/11, the attorneys worked, because of the extraordinary event, the attorneys worked with a much reduced fee.
No, in 9/11, I was a member of the pro bono panel in 9/11. The attorneys worked without compensation, but it only worked because of the reputation of Ken Feinberg and the confidence that was placed in him and the compassion that he showed to the victims. This is not a panacea that works all the time. The key to this, the linchpin, is who is going to be administering this type of program. Unfortunately, there are very few Ken Feinbergs that the plaintiff's bar is going to have confidence in. It could just fall apart just as easily if the plaintiff's bar and the plaintiffs themselves don't have confidence in a Ken Feinberg to make it work.
Sheila Birnbaum has done extraordinarily effective work with a successor to the Victim Compensation Fund, and she did the same as a special master to me in settling a large number of 9/11 cases. Have there been any other special masters of the same kind of work that you do, Ken? Like, who are your competitors?
But I mean, you hear? So there's 1 or 2 or 5 or 10. I mean, is that any way to have a public policy? That's all I'm suggesting.
But, you know, it's really, I'm sorry, Professor Benner. Mr. Beister, sorry.
Ken, a quick question for you. Let's set aside 9/11 for a second.
Activate your...
Whiteland, thank you. And if you're a company that is facing a situation, BP, Volkswagen, why engage in the early process that you have undertaken there when chances are pretty high that there is going to be litigation thereafter? There's going to be a lot of claimants who are going to go through an MDL process and assert their claim. What is the rationale for the early process that you're engaging in?
Well, if you're a foreign company like BP or Volkswagen, you're fearful of the American legal system, and you see, and even if you're not a foreign company like GM, you see a quick, efficient, certain resolution over a limited amount of time, 6 months, 9 months, done, with the certainty of cabinizing the scope of the problem. Your stock goes up 15% the first day. Once you have announced, we're going to set up a program to gain control over this mass problem. And we're going to do it in a way that promotes certainty that we can cabinize and estimate our damage. And I think that there are financial considerations and reputational considerations that go into the decision. But it's only made by a handful of visionary companies, I guess. I don't know.
But you're saying it's worth doing even though the prospects that you're going to resolve the entirety of the controversy through that process, at least the evidence is and the ones that you've dealt with, it's not high, the probability you're going to resolve everything.
That's right. Although they look and see 97%, 92%, 95% versus roll the dice in the courtroom over 2, 3, 4 years. Let's try it. Let's try it. The government, BP, GM, maybe Volkswagen, and the chemical companies in Agent Orange.
Ms. Kuhn. Ms. Kuhl.
I'm not sure it's quite as rare as you suggest, Ken. We certainly in our California courts have had lawyers who have settled cases for amounts of money and then have had that money distributed among their clients by either a judge or a retired judge. Using techniques as you suggest, Ken, where the important thing is that that person has a good reputation for listening. So one instance, for example, was a Metro Rail wreck where people lost their lives, and the federal law created, because it was a railroad, created a cap for that accident. So there was a set amount of money which then was distributed by agreement in plaintiff's counsel. Another was actually the clergy abuse cases. One group of injured people, the lawyer agreed to a certain sum of money for that group of people, and the judge determined, sitting with those injured victims, who received what amount. So Elizabeth may know of other situations, but it's not that rare in what we see.
But that's different. That's like a first cousin of what I do. In those situations, you have, under the umbrella of the court, you have settled for a fixed amount. And now the issue is how to distribute the funds. That's a little bit more conventional. In 9/11, BP, GM, there is no settlement. Mr. Feinberg will set up a separate program and resolve each claim, and we will pay a total of X, depending on what Mr. Feinberg decides in his wisdom.
Well, in both of the situations that Judge Kuhl points out and you point out, the fact that there is an ancillary system in the courts is crucial. It's not so much that a person like you is set up with arbitrary powers. You have within your province, perhaps, arbitrary powers, but they're exercisable only in a system where a person can easily opt out and go into the judicial system. So you can be effective because you can short-circuit the judicial system, and you have certain play in doing that, but I submit that the existence of the judicial system makes what you do fair and effective.
My first point, I completely agree with that.
Yes, Professor Sharkey.
Ken, I'm just curious if you've ever been called upon by an administrative agency to consult or give advice, et cetera, because it strikes me that while you may or may not be right with respect to banning you to the history books for tort classes, I'm reminded, we were in Haifa at a conference together, and one of the Israeli scholars came up and said, Ken Feinberg, he's like an administrative agency in your country. Tell me about administrative law. And there is a kind of parallel, which I know our panel, I hope to explore a little more, but I'm wondering on that.
Yes, I mean, I'm asked to consult, in quotes, but then you consult and go home. I mean, they have no interest in using me beyond, Ken, what do you think about how we might do this? And sure, I consult.
That's intriguing, right? Because that shows what you're doing it'd be worth studying, maybe in an administrative law class.
So I think we've put Ken on the hot seat enough for a while. Go ahead, Judge.
Examples of the cases that you have handled, Ken, do you see applicability of your model to cases where liability is contested? It seems to me the cases that you have handled, the defendants either has been established or they have conceded it for whatever reason. Would this be a mechanism to also address liability?
I think, Judge, the cases I get involved in, the defendant is sort of, at least implicitly, if not expressly, in the public domain, acknowledging liability. And the only issue is how can we best pay the claims? So I think that makes my job a lot easier, that the company is prepared to basically open its wallet. And the federal government was basically willing to open its wallet for a lot of reasons, not all patriotic. And let's just get rid of the claims.
Thank you, Judge Rebrano. Why don't we go on to Professor Rabin, and questions that you want to put to Ken, we'll keep them here, right? And you can do that, but let's move on and have some other points of view. Professor Rabin.
Yeah, well, I'm very pleased to be on the panel. I thought I would give a roadmap, and part of the roadmap has already been covered, a roadmap addressing three questions. What kinds of aggregate claims are candidates for resolution outside the tort system? Why might there be a perceived need for an alternative forum, and what are the viable options outside of tort? So, proceeding along that roadway. What kinds of claims can be identified? Well, personal injury, of course. Aggregate injury claims can arise from terrorist-initiated acts, as in 9/11, of course, or an incident like the recent San Bernardino shooting. For the most part, these are physical injury claims, but not exclusively. It can be a toxic exposure claim. 9/11-2, the Zadroga Fund, is an example. The first responders claims now being addressed by Sheila Birnbaum administering the Zadroga Fund. But more generally, going beyond terrorist-initiated acts, there are aggregate claims against private enterprise or governmental entities with no terrorist connection, and prominent examples, of course, and Ken is involved in the first that I mentioned, the GM ignition switch cases. Perhaps some of the toxic exposure cases that are getting a great deal of publicity now, Flint, Michigan, and other scenarios of polluted drinking water potentially might get settled outside of court. And asbestos, of course, which was settled, has of course been in the courts a great deal, but also with the asbestos claims facility had a forum outside the courts. So personal injury, a wide array really of types of personal injury cases fall within, are candidates, under my first question, are candidates for resolution outside the formal tort system. Then there are, in addition to personal injury, property damage or standalone economic loss cases. And here, again, Ken, you mentioned, and you've been involved in the BP oil spill. Again, in and outside of court, but certainly dominantly outside the court system with the $20 billion fund that was set up by BP. And more recently, in the works now, as I understand it, the VW emissions scandal. Again, an informal settlement in the works of the standalone economic loss type. So that's a kind of sketch of the types, the kinds of claims that can be identified. Second question, why a perceived need for an alternative forum outside tort in these scenarios? Well, this is familiar to everyone in this room, obviously, and in this discussion, we've already gotten into it. One critique, a familiar one, focuses on the institutional inadequacies of tort for resolving, or shortcomings of tort for resolving aggregate claims. Delay, the possibility of insolvency, lack of horizontal equity, or there may be a cluster of tort-specific defenses that drive towards an outside-of-court settlement. For example, Federal Tort Claims Act, discretionary function exemption, or a state counterpart that makes cases like Hurricane Katrina and the neglect of safe drinking water standards difficult in court, but perhaps can lead to a settlement outside of court. Proximate cause limitations in terrorist-initiated incidents, again, may cut off some avenues within the judicial system, but still create avenues outside of tort. A second critique would focus on tort better serving exclusively as a default forum, perhaps limited to large claims or protection of victims' rights to express grievances. It may be that horizontal equity and welfare considerations can better achieve efficiency and justice ends in the mass of more modest claims, but regard for individual rights seems especially compelling for large loss claims. So that would be a second critique that would focus on having at least some of the claims in an aggregate package settled outside of court, rather outside of the judicial system rather than within the judicial system. So then I come to my third question. Yeah, go ahead, Judge.
Are you thinking that there should be a systemic definition of what can come in and what can not come in?
Well, it's possible. I mean, we see that. This is outside the aggregate claims area, but we see a systemic definition, for example, in an auto no-fault plan. In the New York auto no-fault plan, the first $50,000 of economic loss are outside the tort system, are resolved by a no-fault, under a no-fault system. Larger claims, the very large dollar claims, and also pain and suffering claims, by definition, go into the tort system. So you can have a system that is two-stacked, partly for horizontal equity, as I say, and other reasons, might dispose of the smaller size claims outside of the tort system, but leave the large dollar awards and the large grievances to be resolved within the tort system. So what are the viable options outside of tort then? My third question. Well, no-fault administrative compensation schemes have a long lineage, of course. Workers' comp takes us back over a century as a complete replacement for the tort system. Actually not a complete replacement. Judge Hellerstein, as you said, the tort system is always there one way or the other. Even in workers' comp, it's there in one sense, with third-party claims against manufacturers, for example, who supplied equipment that causes injuries in the workplace. Tort system's still open to those cases, even though the claims against employers are all within the tort system. So workers' comp, of course, goes back over a century, auto no-fault, but those are ongoing case-by-case, not aggregation of claims schemes. So they're different from what we're talking about now. They set the foundation, they're the lineage, but historical lineage, but they aren't what is our subject today. Our subject today, the most familiar scheme, is not an ongoing scheme, of course, but the 9/11 Fund, which is illustrative of a government-funded aggregate claims scheme. And in fact, it's not just one scheme, but two, because there is the second 9/11 Fund, that the Zadroga Fund that Sheila is administering, that is dealing with the long latency claims, the toxic claims of first responders. So no fault is one option outside the tort system for resolving claims. The Zadroga Fund, just a very quick footnote on it, it's an interesting variant actually on the no-fault model because it has a degree of expertise that again is an argument for going outside tort and resolving particularly certain types of toxic claims. The Zadroga Fund is actually two funds. There is a World Trade Center health program, and that program determines the eligible diseases. And then there's the compensation program that Sheila's administering, and that determines the benefit decisions. So one option outside tort is no fault. Another is agency adjudication of mass claims by resort to judicial MDL and Rule 23 type tools. An example of that is the Vaccine Act omnibus proceedings, most notably the mass disposition of the thimerosal autism claims, which were resolved by reliance on test case, expertise-based administrative proceedings. Now, a variety of those techniques are spelled out in the recent administrative conference report, Aggregate Agency Adjudication, which was authored by Adam Zimmerman, who is here in attendance, and he might want to talk a little bit more about that. Kathy, perhaps you're going to as well. So that's a second option. A third, and this is the one that created our earlier dialogue, a third option outside the tort system is private enterprise initiated compensation schemes. And here we have the GM Ignition Fund, the BP Oil Spill Fund, and I suppose one could put the asbestos claim facility in this category as well. A fourth option outside tort, and this is of a different kind. Government-initiated first-party insurance schemes covering property damage. Now, that is probably most relevant to natural disasters, but there can be spillover to displacing potential mass tort claims, particularly against governmental entities. And just two examples. One, the California Earthquake Insurance Authority. That's a state agency, and it underwrites coverage, very expensive coverage, I might say. Most of us are in a state of turmoil every year when we get the bill in California for annual coverage, and most of us decide to grit our teeth and hope that an earthquake won't do damage to our property and don't take the coverage. But it's there, and in the case of an earthquake, a very serious earthquake, if there were tort suits that might follow against either a governmental entity or private entities, it might very well be that the first party coverage would limit resort to tort in that situation. Another example is the flood insurance. It's a federal agency, FEMA, that administers flood insurance. Once again, flood insurance coverage, when it comes into play, might very well limit potential aggregate tort claims that might otherwise be brought. Now, both of those are voluntary programs. It isn't compulsory for potential victims to carry the insurance, although mortgage lenders may require the coverage in some instances, but the coverage could displace resort to tort in some cases.
Well, what does it do now? It's a person makes a claim to his insurance company. The claim is adjusted in some fashion, and if it's adjusted to the satisfaction of the insured, that's the end of it. If it's not to the satisfaction of the insured will sue. So where is the model that's the alternative?
Well, I'm not sure I understand the question, Judge. The model is a first-party insurance system like, let's stick with the California earthquake insurance, that if in fact individuals were to decide that in fact their property was poorly designed, and if it had been designed according to standards, they might very well have withstood the earthquake. And with that in mind, they might bring a tort suit against a housing contractor, against the architect. It may very well be that if they have full coverage under the California earthquake insurance system, the tort suits won't follow. Now, it may be that there'll be subrogation, and that here's where the tort comes in again. Possibly there would be subrogation in cases like that, particularly if there are a huge number of claims of this kind. The California Earthquake Insurance Authority might decide to subrogate and bring tort suits against the third party. But that's kind of how the system might very well work. A final note. Just let me sum up. Because the aggregate damage claims can be triggered by such a wide variety of sources, I think it's futile to look for a single forum alternative system outside of tort. I think Ken is way, way too modest in dismissing his option among these many that I've suggested, the option of resorting to Ken or someone like Ken. But where expertise-based fact-finding is a dominant concern, then no-fault models have significant advantages. Where victims' rights considerations, including timely redress, seem more prominent, then privately initiated compensation schemes may be more attractive. In the end, from an institutional perspective, the resolution outside tort is probably destined to demonstrate the same patchwork character that the tort system has. But having said that, as my final word, there are shared premises underlying these efforts to resolve aggregate claims outside the tort system: a reliance on scheduling of awards to achieve greater horizontal equity and rapid resolution of claims, an effort to realize efficiencies in the administration of awards, and in the case of aggregate toxic harms, or reliance on greater expertise in establishing eligibility for benefits. So that's a quick roadmap of outside tort as I see it.
2 minutes of questions? Yes.
I just feel compelled to describe yet another mechanism that I've been spending the last 15 years of my life in, outside of torts, in the environmental field, in the Superfund area, picking up on Judge Robredo's point and Judge Scirica's point. It's a quasi-arbitration, in effect, where parties get together and design their own dispute resolution system, hire an allocator. I've done 7 of these so far, and I'm now involved in 2 very large river sediment sites, both one's over $1 billion and the other one's $500 million, 144 parties in one, 44 parties in the other. Strict liability is the standard under Superfund, so parties know they're going to be responsible, and they can't afford a court-based resolution because the discovery would just be enormously expensive. And so they hire an allocator to develop all the facts and then receive argument from the parties. An allocation is written, there's an opportunity to respond. The allocation is then finalized, and as I said, I've done 7 of these, and in every case, the allocation, while it's not binding, has always been accepted by the parties. Because, again, their alternative is to put this in front of a judge, and it's just too expensive. And then a slightly different version, nature also can be impacted by harm and not just individuals. And for the last, 13 years now, I've been serving as a special master overseeing the consent decree governing the restoration of the Florida Everglades, dealing with United States, the state of Florida, an Indian tribe, 3 cities, 12 conservation groups, and again, all done essentially outside of court. I mean, I've been appointed by a federal judge, but we work things out in private conferences and hearings. So there are lots of adaptations of the model that can work.
Thank you, Mr. Barquette. One other question, then we'll have Professor Sharkey. Yes, sir. What's your name?
Yeah. It strikes me, one other thing you could add to the roadmap, I guess, are agency restitution efforts, as well as criminal prosecution restitution efforts, where the agency pursues criminal restitution against a corporate wrongdoer and then distributes the proceeds. I know Ken has been involved in at least one of those types of proceedings. My question is that the title of this panel is outside of Article 3, aggregation outside of Article 3. And it strikes me that among the roadmap that you've listed, that it's quite possible that you could have multiple forums for mass compensation proceeding at the same time. You could have an agency restitution effort, a criminal prosecution, a bankruptcy, you could have a private compensation fund, and proceedings that are taking place in front. What should the role of the judge be when there is this, at least potential, for multiple proceedings to be taking place at the same time? Ken has used the word managerial at times, but I always thought of Hellerstein's relationship with the September 11th Fund as a little bit more facilitative, a standing order saying, talk to Ken first before filing.
I did not want to set up the court system as a competitor.
Yeah.
I wanted them to finish with Ken before they came to me. But it may differ in other places. I don't know that you can have a blanket rule. Anybody want to come in on this? Ken?
Probably asbestos. Probably asbestos is the prime example of overlapping compensation systems. You've got the trust funds, you've got workers' compensation, you've got private insurance, you've got Medicare, Medicaid, you've got the litigation system under Judge Robredo. And I would say one of the notable concerns right now is exactly the point that you're raising, that there isn't coordination as among those various compensation systems. John Beisner can address that specifically concerning the trust. But I would say that is a critical issue. Ken, you may disagree with me on that.
I just wanted to say when Professor Rabin talks about a schedule that promotes horizontal equity, watch out. Watch out. You think that you have a schedule promoting horizontal equity. But when you aggregate claims, everybody counts other people's money. Everybody. It's human nature. Mr. Feinberg, you've slotted me in here, and my next-door neighbor's getting 30% more. What do you have against my dead wife? You never even met her. And I mean, it just goes with the territory that you may reasonably have a Professor Rabin blessed schedule. Just brace yourself for the reaction of the very people you're trying to help, and instead that schedule promotes unbelievable divisiveness.
Let's hear from Professor Sharkey now, and then we'll...
Well, can I just say one word?
I'll cede a minute for
Yeah, but Ken, you've taken that to the extreme. You've said many times that perhaps there should be full horizontal equity. Everybody should get the same amount. So that would really be watch out in spades.
If you gave everybody the same amount, it would be a lot easier. Your next door neighbor's getting the same as you. But then you're not tied to the hip of the tort system. Because if you're giving everybody the same amount, $250,000 each, let's say, well, the stockbroker is going to opt out of that program and go to the tort system. So anytime you tie a program like BP or 9/11 or GM to the tort system requiring a full release, everybody by definition is getting a different amount of money.
Sheila?
Thank you. I'm sorry, I was on another program this morning and missed the beginning of this. But Ken is right. If there's going to be anything that has to be tied to the tort system, it has to be done in an individual kind of way. And even in the revised 9/11 fund, that is still tied to the tort system, although we have set a schedule for different non-economic relief that looks into what the injury is, and they fall into a certain category for non-economic relief. But for the economic relief, it is more or less geared to the tort system with a little less, because now there are caps on what the income levels could be in the third revised 9/11 fund. So I think you can't have across the board for economic loss if you're tying it to the tort system.
Professor Sharkey.
That was a long minute I ceded, but I'll be quick.
You created a problem for yourself.
I can speak quickly.
But I'm saving time at the end, so you're okay.
Okay. I want to actually just pick up on a theme that Ken began with, and I think Bob pushed forward too, which is the role of judicial oversight. Particularly, I guess I would situate the theme as follows. We could think, Judge Scirica, you started us out by saying we sometimes we should focus on who should resolve these kinds of cases. And we could think about courts and agencies. And sometimes people think about these as agencies are sort of the public counterpart to what happens in class action litigation or things before the courts, and they're kind of separate schemes, and we'll leave the public agencies to administrative law scholars. I previewed, in some sense, part of the idea I wanted to interject into this conversation by asking Ken whether he'd been consulting in the administrative context and thinking about some parallels between what he does and an administrative agency. So what I want to do here on the panel is I was really struck, Bob alluded to this new Administrative Conference of the United States report that's co-authored by Adam Zimmerman and Michael Santambrosia, and it's called Aggregate Agency Adjudication. And this report fascinated me, partly because a lot of my own work, which I would bore you with, except I don't have enough time, has been looking at ways in which courts could harness administrative law principles in what they're doing. And I see what this report is doing as actually trying to harness tools of aggregate litigation into the administrative law process. So it's fascinating, and they go through several case examples. I'm going to point to one. Bob also alluded to this, the vaccine injury compensation scheme. So just one prefatory note, Congress typically, in its infinite wisdom in our federal system, will intervene to set up federal standards of care and almost never thinks about compensation. And this leads to a huge debate between whether any time the Congress intervenes in an area, it's displacing state tort law, is state tort law regulatory or compensatory, all of these kinds of debates. In the Vaccine Injury Act, Congress also created a separate compensation fund and a separate scheme to happen in a non-Article 3 context with special masters to adjudicate these claims. And so what Zimmerman and Santambrosia do in their report is showcase this as an area where even without specific protocols to doing aggregate proceedings, there have been, particularly with respect to the autism cases, the cases that were alleging a link between certain vaccines with thimerosal and autism, there were something like over 5,000 claims that were basically aggregated in this omnibus hearing. Now, what's interesting is the APA, which came into play in 1946, clearly didn't think about agencies doing aggregate proceedings. And there's an interesting administrative law doctrine that tells courts that they shouldn't engraft additional procedural requirements onto what agencies are doing. So in some sense, that gives agencies a lot of free rein in this area to come up with their own procedural requirements. They could borrow from Rule 23 or not as they see fit, et cetera. The Vaccine Act, and this is something that's not explored fully in the report, so I guess I put this forward as a bit of a provocative challenge, also specifically had, and I want to quote from this provision, it gives the United States Court of Federal Claims, which is the one under whose auspices this system is set up for appeal, to, quote, provide for limitations on discovery and allow the special masters to replace the usual rules of discovery in civil actions in the United States Court of Federal Claims. So what's interesting is, on the one hand, we have this system that was set up, the Vaccine Injury Act wanted parties to first, it's sort of like the equivalent of go to Ken first before you come to me. They wanted parties who were injured under having taken vaccines to go file their claim with HHS first. And then in 1986, at least, there wasn't a whole lot of thought put into what would happen next, except presumably the idea was if you're unhappy with that resolution, then you go into federal court and you appeal this. All of that is well and good, except, and this is an area that's near and dear to my heart, in 2011, the U.S. Supreme Court ruled in a case called Brusewitz that an individual who tried to go before the vaccine court, wasn't satisfied, and I'll get into that in just a minute, tried to sue in court, was preempted. So basically read the 1986 Act as saying, oh, well, if you go through that route, Congress sort of set up a quid pro quo. You can get this kind of compensation, but you can't then sue for a design defect in court. The reason I think this is important is because I think there are two issues that if we're going to take seriously this project, or take seriously what Zimmerman and Santambrosia, I think, descriptively show as a burgeoning interest in agencies in doing aggregate resolution of claims, I think we should be thinking pretty long and hard about what kind of judicial oversight we will have from this, how feasible it will be for courts to be prompting agencies in the right directions, with two sort of formidable stumbling blocks. One might be preemption, and certainly is going to be a stumbling block in this vaccine context. A quick note about the vaccine fund that also is not often explored, and this should be taught more in tort classes, is that when Congress set up this fund, they set up a vaccine injury table. And the idea is that there'd been enough scientific research that if you took one of the 7 identified vaccines and got a certain condition within a certain period of time, you would basically get a presumption of causation. And so it was supposed to be fast, streamlined, et cetera. That's why we could limit discovery. That's why this whole system made sense. If you fast forward to today, there's there's a special master within the system who's calculated that 90% of cases today are brought off table. So what does it mean when you're bringing a case off table? It means you have no presumption of causation. So it means you're before this entity, this non-Article 3 special masters process, like you're in trial trying to present causation. And in the Brusewitz case, interestingly, the plaintiff's claim before the U.S. Supreme Court about why this, one of their claims, why this shouldn't be preempted, was because if you're going to limit our ability to do discovery, if we're going to have these tools that were set up part and parcel with this streamlined administrative compensation scheme where causation was presumed, right? If you're going to do all of that, but we're in a situation where we have to prove causation, then you're going to be hamstringing our ability to make our claim. So that's one of the formidable barriers I think we should think about in this context. And then the second I alluded a little bit to is this problem that in administrative law we call the Vermont Yankee problem, which is that courts can't engraft procedural requirements onto agencies. And there's a recent Supreme Court case called Perez that some are calling the Vermont Yankee 2, or the second coming, if you like. So this is sort of to get law review articles published, to call it the second coming, I think. But the idea that the DC Circuit in these lines of cases has been restrained from basically engrafting procedural requirements when it was very well intentioned to try to make sure that these administrative processes were fair, legitimate, accurate, et cetera. And so I guess the challenge, or what I'd like to hear some more discussion about here, is if it's right that agencies not only have started sort of below the radar, and the report that Zimmerman, Santambrosia talk about mentions not only the vaccine system, but EEOC and some Medicare type claims. So if that's happening, and if we want to encourage that happening, I think we have to give a lot more thought of the kind of judicial oversight that can harness that kind of administrative law procedure. Thank you.
Anybody?
Hi, Judith Resnick. I just wanted to, Bob Rabin talked about whether we want to think about workers' compensation as a kind of class action, aggregation or not. And so issue classes say what will be liability. And so if you have liability set through some system, you could think about that as a form of aggregation. The second question is whether you're aggregating for damages or other kinds of relief. There's a pending case before the Veterans Administration that some of us have worked with under Adams' tutelage, with Zimmerman's tutelage, on an amicus brief about the capacity to have class actions before the VA and a whole bunch of other agencies. And some of the questions are injunctive, or questions that aren't about damage allocators, but rather about what the rules should be as well. So it might be helpful as we're thinking about class aggregation in and outside these multiple venues, and we're looking at all these pop-ups because everybody's aggregating in different ways. One would be, when do we want to call it aggregation and when not? And don't know if we all agree about that. The second is aggregate for what, given the predominance in the last years of the economic aggregation distributions, with Ken as a flag bearer, or standard bearer, I guess is the right word for that. They dwarf the understanding of the vibrancy still of potential relief in injunctive kinds of settings in a variety of places, and in agencies are a place. State courts are obviously a huge other place that is not Article 3. Rule 23 was a paradigm. Should that be still driving our conversation, or is there a way to learn from these other places that actually there are other ways to solve some of the Rule 23 problems?
So I think Professor Resnick is using aggregation in a different way from what was been implicit, I think. We have been using aggregation so far outside the tort system as a method of disposing of many claims on individualized bases. I think Professor Resnick is talking about massing various claimants to make various kinds of agenda points, not necessarily in terms of distributing money, but in terms of other social purposes. I think there are two different things we're talking about. In answer to Professor Sharkey's question, and I think some of the other judges may want to come in on this, most times we rarely see appeals from the administrative agencies because they tend to go to the courts of appeals. Occasionally we get them. For example, from the Social Security Administration. Rare cases from immigration. Most of them go to the courts of appeals. The problem there, even whether we do it or the Court of Appeals does it, is that you have a substantial evidence rule, so that it presupposes some kind of formalized claims procedure in the administrative agency, some kind of a determination, and then deference being given by the Court of Appeals. But in the absence of rules, in the absence of open standards of distributive justice, I don't know what the standard would be.
I've argued in certain contexts that courts could apply more of a hard look review as opposed to deference in certain situations that are empirically or fact dependent. And part of what's interesting about the Zimmerman-Santambrosia study is they seem to be gesturing towards a role for judicial oversight in terms of forcing agencies to give reasons on the record as to why they're adopting certain procedures, et cetera. And it's quite similar to something I've argued with respect, just to give you a concrete example, when courts are faced with preemption determination and they need to decide, does the FDA's approval of this drug preempt the tort claim? I've argued that courts actually have a mechanism whereby they can give a hard look review looking at the administrative agency record on whether the agency weighed the precise risks before it. And I find there's a parallel. I don't know if Adam would agree at what you at least gesture towards with respect to having courts play a role of being information forcing, reasons giving forcing to the administrative body. And I find that very interesting because I think that there's room for courts in their application of deference in the administrative context to rethink sort of how much of a hard look review they can give to certain of the agency's decision-making processes.
Yes, Professor Zimmerman.
Yeah, I'll follow up. First, thanks for plugging the report, and if I'd really love to hear your thoughts about it. It's actually online. I can circulate it because right now we've made recommendations that the administrative conference would vote on in June, and if they adopt them, then it would essentially allow other agencies across the administrative state to begin to use aggregate techniques a lot more often. So I'd love to hear your thoughts about what we've recommended and what we write in the report. On Judith's point, I think it's worth thinking about these different reasons for why we aggregate. And in our study, what we found were that there are at least 3 reasons that and different purposes served by aggregate. One is the enabling of litigation, or the enabling of litigation to supplement the agency's ability to enforce the law. The EOC seem to like this idea, sometimes enabling the ability of workers in a workplace who have the right to, when their government workers bring claims, to bring those cases up before the EOC. More often than not, however, agencies don't like enabling claims. They have enough of them. And they're thinking about ways in which they can use aggregation to resolve them. And so another reason for aggregation is peace or certainty, as Ken was talking about. And the third that Judith is alluding to is what you can almost call democratization, which is, there are a number of ways in which agencies will make decisions that, usually with declaratory orders, that might impact a greater number of people than just the person in front of the agency. And so they seek to use aggregation tools as a way to just kind of broaden the reach and voice that people can kind of have in the process. And in fact, like the EOC's class action rule, which is modeled on Rule 20, is modeled on Rule 23B2, which is the declaratory relief rule, and precisely to improve the input. They actually don't have the ability to opt out. The EOC's class action rule doesn't allow, so even when people seek damages, there's no opt-out right. And it's precisely because so much of the focus of that rule was just improving voice. So I think it's worthwhile to think about what the purpose of the aggregation is in thinking about the technique. The second, and the only other point I wanted to make was that it strikes me that when we're thinking about judicial review, it seems like there's like at least 3 different models for judicial review. One can be, or the judicial role. One can be this kind of facilitative role that Judge Hellerstein, you were describing. Just I wanted Ken to be, I wanted the victims to talk to Ken first, and you created that open dialogue. Another can be information forcing, where where the judge's role is to kind of just get more information out about this alternative process that's out there so that it's just a more informed one. And the third could be like a more aggressive and managerial role.
I'm going to talk about that this afternoon. Yeah. But we've got now the last speaker, Deepak Gupta, to send us on our way with a lot of take-home information.
Okay. Well, thanks for everyone for having me here. This is actually my first ALI conference, and this has just been a fascinating discussion. So Elizabeth asked me to talk about arbitration as a site for aggregation, or what happens to aggregate claims when they go to arbitration. And the question here is, whether there can be any aggregation or whether there can be any resolution of the claim. So this is where you don't have Ken Feinberg, you don't have an administrative agency. Instead, you have something that can be regarded as privity of contract. So these contracts are now ubiquitous, of course, in consumer and employment contracts, but I think we're going to start to explore new frontiers in what we can regard as privity of contract. I've seen there's a hamburger joint in Texas where you walk through the front door and it says, by coming into this restaurant, you agree to arbitrate any claims you have against us. You probably will start to see shrink wrap on products that you buy at retail, and any kind of online transaction. And so the world of contract, I think, is going to expand, and the Supreme Court has given businesses license to do that because it's a recipe for limiting their exposure to class liability. And I should say, I don't come at this from anything like a neutral perspective. I represented the plaintiffs in the Concepcion case and in the Italian Colors case in the Supreme Court, and then after that I was at the Consumer Financial Protection Bureau, the new federal agency working on this issue. And I think, so what I want to talk about very briefly in the time available is sort of three ways of looking at this: individual arbitration, class arbitration, and what I'll call mass arbitration. And that's something we really don't know very much about yet. So first, individual arbitration. The picture here is really claim suppression. Judge Scirica said that he alluded to AT&T versus Concepcion and said that we're seeing this means that we're resolving a lot of aggregate claims in arbitration. I actually think that's not true. What's happening instead is that the claims are just being killed. They're not going to an alternative dispute resolution system that is better, faster, and cheaper. Instead, the very claims for which the class device was created, the sort of prototypical small dollar claims where the economics of aggregation make most sense, those claims are disappearing for precisely the reasons that they were appropriate for aggregation, right? They're not feasibly vindicated unless they can be aggregated, and there's an entrepreneurial lawyer who's willing to take that task on. And so Professor Resnick has an article in the Yale Law Journal that beautifully lays out what we can tell. It's very hard to get all of this data, but that shows, I think, very convincingly that the effect has largely been claim suppressive. The Consumer Financial Protection Bureau has authority from Congress to write rules in this area, and last year put out a 900-page report. It's the most empirical work that's been done on the effect of arbitration. And what it shows, it's 900 pages, so I can only give you one or two highlights. But one stat that I think is pretty revealing, so the American Arbitration Association, the leading arbitral forum, opened up their files to the CFPB. And they looked to see in 2010 and in 2011 how many affirmative claims for $1,000 or less were resulted in relief for consumers, monetary relief for consumers. And this is of all of the claims that are within the CFPB's jurisdiction, which is a very wide jurisdiction: mortgages, credit cards, student loans, fair debt collection, fair credit reporting, very, very broad jurisdiction. And what they found was that the number of people who received monetary relief for those kinds of claims under $1,000 in a 2-year period was not 4 million people or 400,000 people or 40,000 people or 4,000 people or 400. It was 4 people. There were 4 people who received monetary relief on their monetary claims. And I think that shows you that the effect is simply to kill the claims. Another really revealing piece of the study, because it's so hard to find the counterfactual and to demonstrate, what happens if you...
How legitimate are the claims?
Sorry?
How legitimate are the claims? They're often based not on any loss, but rather on a statutory provision that you can get $250 if you're been hit by a credit card bill collector who leaves out some kind of specific piece of information.
Right. So the example that I want to point to actually is an indisputably legitimate claim. It involved sequential reordering of transactions by the banks in order to increase overdraft fees to consumers. And this practice, I think, is widely regarded as indefensible. The banks are not doing it any longer. 23 banks were doing this, and they were sued in a series of class actions. And the only real variable that accounts for what happened to consumers in these cases was the absence or presence of an enforceable arbitration clause. So there were 18 settlements. There were consumers received $1 billion in relief, and you don't have a claims rate problem here because the money was just deposited into the consumers' accounts. And yet for the consumers who were with banks that had enforceable arbitration clauses, the CFPB was able to find only 3 claims that were prosecuted in arbitration and wasn't able to verify that any of those consumers received relief. So there you have it, the difference between an enforceable arbitration clause and an unenforceable arbitration clause, or the lack of an arbitration clause, is either relief for an indisputably meritorious claim on the one hand, or nothing. So that's really the effect of arbitration, individual arbitration, at least in the consumer context, and I think there's a similar picture in employment and antitrust and other areas. The most promising development here is that the CFPB is poised to write rules that will ban class action bans, effectively rechannel those cases to the courts, and also require transparency. And of course, there will be a big battle over that rule, but it should come out in the next few months. The next category of cases where we could look to see what happens for aggregation in arbitration is class arbitration. And I think it's appropriate to talk about class arbitration now in the past tense, because while there are a few cases kicking around that are still being aggregated in the arbitration system, they're largely relics, because the Supreme Court's jurisprudence has made it very, very unlikely that those cases are going to end up in arbitration. All a company has to do is write a clause that says no class arbitration. And in fact, even if there isn't such a clause, silence under the Supreme Court's decision in Stolt-Nielsen means that that case cannot be brought to arbitration. So it is worth looking at class arbitration as a model, though. Between 2003, when the Supreme Court seemed to endorse class arbitration in the Basel case, and Stolt-Nielsen, there were hundreds of cases that were brought in the American Arbitration Association and other forums that were aggregation in the arbitral forum. As an advocate in Concepcion, I had to be somewhat supportive of this, because the Supreme Court's preemption jurisprudence under the Federal Arbitration Act asks you to be neutral as between arbitration and non-arbitration, right? So the California law at issue in Concepcion was neutral as to whether the aggregation would occur in arbitration or in litigation. It just insisted on some aggregation. But I think actually there are a lot of problems with having aggregation in the arbitration system, a lot of difficulties in terms of how you ensure due process, how you ensure protection for absent class members. And the AAA's response to this was to write rules that made arbitration look more and more like a class action in court. It made them public. It had very similar certification procedures. It really essentially adopted large parts of Rule 23. And then what you found is that the cases looked a lot like class actions in courts. They took about the same length of time. But businesses regarded this as the worst of both worlds, because you had private arbitrators who could be deciding the fate of that business, and yet there was no appeal, and they were subject to very limited review in courts. And so sort of all of the features of arbitration that businesses might like ended up being turned against them. And so it's hard to see how we're going to return to a world of class arbitration, because the business community is very much against it. And meanwhile, the plaintiffs' bar and regulators are more inclined to insist on court procedures. So the last category that I want to just flag for everyone is what I'll call mass arbitration. And we really haven't seen this. We've only seen inklings of the possibility. There were a series of cases that were aggregated by some lawyers when AT&T was in merger talks, antitrust claims challenging that merger. And what was interesting is they used the very same arbitration clause at issue in AT&T versus Concepcion against AT&T. And AT&T actually brought litigation claiming that was in effect a kind of class action, and that in their view it would be preempted by the Federal Arbitration Act. That never got adjudicated. But it shows you that there is this possibility that entrepreneurial lawyers who are no longer able to bring class actions in courts can figure out ways to make the economies of scale work in arbitration. One model that's been suggested by Miriam Gillis in a recent paper is something she calls a hybrid model, where you can imagine that first the lawyers go out and obtain some precedent in the judicial system, or a public enforcement agency obtains some precedent in the judicial system, and then that precedent is binding, and the lawyers then aggregate the claims and attempt to vindicate individual claims en masse in arbitration. In fact, the very practices that were at issue in American Express versus Italian Colors were also the subject of a Justice Department antitrust case against American Express that resulted in a finding of liability. And so there are entrepreneurial lawyers right now who are trying to gather the claims of merchants around the country and see whether they can use American Express's arbitration clause against it. That's probably the most promising frontier so far. Other possibilities that have been suggested are using social media to aggregate consumers and then bring those claims into arbitration. But it's very, very hard to do that. It's very costly and very difficult to assemble all of these people and to bring those claims. And a third possibility is some kind of assignment.
So it's really an opt-in type of class.
That's right.
A lot of people coming together to opt in and bring 100 plaintiffs versus somebody.
That's right. That's right. But you'd still have to do it. The reason I say it's like a mass action is because you'd still have to do it as kind of, a series of individual claims, and then there would be a fight about whether that's effectively consolidation.
Could you have a single arbitrator do all these claims?
Right. Exactly. Which could be quite difficult and perhaps even inefficient. And then the third possibility is some kind of assignment mechanism where you could have people assign their claims to one entity that would then prosecute those claims. Now, you could imagine that companies would draft anti-assignment clauses to try to prevent that, but an arbitration clause has to have mutuality, and companies like to assign their claims to debt collectors and other people, so that might not be possible. There could be tricky standing requirements because, some statutes say that the claim has to be brought on behalf of a consumer, right? This would be a third party. But that's at least a possibility, and all of these possibilities are just possibilities right now. They're really in the infancy, and it's sort of surprising, actually, that 6 years after the Concepcion decision, the entrepreneurial plaintiffs' bar hasn't figured some way to make this happen.
Judge Rosenthal.
It sounds like, in a way, what you're describing is an MDL for arbitration. Would it require a statute to create that? Could it come into being without some sort of congressional authorization? That's my first question. Mm-hmm. And as you've described it, it's kind of an MDL on steroids in that it doesn't have the lexicon limit because there is no statute in place. Right. So it would not only resolve the threshold or common pretrial issues, but it would also resolve the merits of the claims and the amounts to be dispensed, if any, and how that was to be accomplished, as well as the kinds of things that the MDL is now allowed to do within the statutory limits. So I've got kind of two different questions. One is, can you do it without Congress giving you express permission, number one, and number two, if you were to have these expanded authorities, what kind of regulatory scheme would you imagine that would be required in response to that? Procedural scheme, regulatory scheme, whatever you want to call it.
So I think the answer to the first question is statutory authority would not be required, because the idea is that this is a creature of contract, right? The arbitrator derives its authority from the contract, and the parties would simply be availing themselves of the procedural rights that they have in the contract, and admittedly pushing them,
But somebody has to authorize the grouping of those to a single decision maker.
Well, I think
in this case, an arbitrator.
Right. Then there would be a fight within the arbitration about whether some kind of consolidation is a violation of a provision that says you can't have class arbitration, which all these clauses have, right? And so I could imagine, the problem is the efficiencies so counsel in favor of something like consolidation that whether you want to call it that or not, it's hard to imagine if you're the decision maker faced with identical serial claims that you won't figure out some way to process them efficiently, and that starts to look more and more like aggregation.
Yes.
The problem in this area is obviously the asymmetry of stakes between the small value that this has to any individual consumer and the large value that it has to the seller of the services, which is a mass seller. The initial response has been to try to use class actions because that provides an aggregation on the consumer side, and it provides relatively cheap aggregation because there's a court process and you don't have to contract with each individual. We had a discussion about this at a conference we held a few months back here at NYU through our Center on Civil Justice on the question of litigation finance. And there was a paper put forward that got a huge amount of attention by a recent graduate of ours, Tom Coyle, which will come out sometime soon in the NYU Business Law Review. And the proposal was that litigation finance could pick up this charge, so that if you look at the fact record of Italian Colors, as Judge Pooler notes in the Second Circuit opinion, it costs roughly $1 million to prepare the underlying expert analysis necessary for an antitrust claim of that sort. Well, no individual is going to front $1 million on a couple of hundred, couple of thousand, couple of $10,000 claim. But that doesn't mean that an entrepreneur wouldn't do it. Certainly a class action plaintiff's lawyer would have to do it, and so you have that model of entrepreneurship. But you also have the private market as a potential aggregator with entrepreneurial spirit. And the idea is you go out as a finance entity, you purchase the expert analysis that's necessary to be done, and then you sign people up one by one, a model that developed in Australia and is now spreading in the United States, and you say, we will rent you this report, as it were, for purposes of your arbitration, and either you use our lawyer or you use your own lawyer or what have you, but now all of a sudden the scales are not exactly the same, but they are brought into alignment. So we have look, I'm no fan of the Italian Colors decision and so forth, but we have to think that there are other mechanisms of aggregation besides Rule 23 and administrative agencies. One of the most powerful aggregators in American history has been the market, and maybe there is more market potential than we have realized up till now.
I think that leads us into our next subject. Thank you, Professor Zakharov. And thank you for the panel. The next moderator is Judge Rosenthal. Judge Lee Rosenthal I cede you whatever powers I had as moderator.